Okay, so we've made the general assumption that the Fair Debt Collection Practices Act does apply. You are collecting third-party debts on behalf of another, and the debts are for personal, family, or household use, and they are in default. What is the first thing that you need to do? Well, the federal statute requires you to send a notice, a written notice containing certain disclosures, and we'll talk about what the disclosures are as I've shown on the next slide. It's called the 30-day validation statement. This is required under 1692G, in which the debt collector is required to provide this disclosure to the consumer. Generally in the industry, a debt collector will send this notice as its first attempted communication to the consumer. Usually this letter will be mailed to the consumer at their last known address provided by the original creditor, or maybe an address that had been obtained by the debt collector subsequently through skip tracing items or different methods to obtain the address, and this letter is mailed out. It's particularly important, and I'll go through the elements of this 30-day validation. It's important that this notice goes out. It's a violation of the Fair Debt Collection Practices Act not to provide this notice to the consumer. There is a provision, as you can see in the statute, that this written notice has to be provided at least 5 days after an oral communication. So if your first communication with the consumer was orally, this notice needs to go to the consumer within 5 days. Practically speaking, in the industry, this letter is usually the first attempted communication, and collection agencies, in the abundance of caution, will initiate either written communications or oral communications after this letter has been mailed. It's usually called the first notice, the 30-day validation statement in the industry, and it's very important that this goes out. So let's take a look at what this statement actually says. The language that I have put down in this starts with, unless you notify this office within 30 days. This is called the 30-day validation statement. We'll talk about the different provisions of this, but this statement and the language that I've used here, if you use this verbatim, this is the language that has been approved by ACA International, which is the trade organization for debt collectors, and has usually been tested through the court system as the most effective and the most compliant that's provided. So if you're going to use validation statements, try to use this language verbatim. I've highlighted certain sections of this. In practice, do not highlight these sections particularly. I wanted to point out certain things in my discussion as to these particular sections, but in general speaking, when you are writing the letter, do not use bolding and shading in your letter. Now we'll talk about overshadowing and contradictions here in a moment. But when you're using this disclosures, forget that I've bolded this out and use them verbatim language. And let's talk about these different sections. The first paragraph or the first sentence that is used, unless you notify this office within 30 days after receiving this notice that you dispute the validity of the debt or any portion thereof, this office will assume the debt is valid. A consumer has the ability to dispute the debt at any particular time that you're seeking collection. The statute provides a window where the consumer can provide a dispute to you within 30 days. Notice that there is no requirement in this sentence that the dispute be in writing. A lot of common misconceptions comes out with debt collectors that the dispute has to be in writing. That's not true. The dispute can be orally and it can be in writing as well. It's usually coupled, and we'll talk about the validation section, which has a requirement to be in writing. Usually a dispute will be coupled with a validation, but an oral dispute is just as effective. The 30-day period of time under the statute merely provides the debt collector with the assumption that the debt is valid if there's no dispute received within 30 days. However, practically speaking and legally speaking, this presumption or this assumption has no legal weight. You cannot assume, and it's not a waiver, that the debt is valid. It's just that the debt collector can presume and proceed with collections if there is no dispute. However, if a consumer does provide you with a dispute 35 days after the fact, we'll talk about one of the requirements under the Fair Debt Collection Practices Act to communicate that dispute, but it has no legal weight. from that point on if they make it within 30 days. It's just a legal presumption, but it has not carry any legal weight as far as a waiver in any form. The second sentence of the validation statement talks about if you notify this office in writing within 30 days after receiving this notice that you dispute the validity of the debt or any portion thereof, this office will obtain validation or verification. This is very important. The consumer has the ability to ask for validation or verification of the debt. What does that mean? Well, unfortunately, validation or verification is not identified or defined within the statute. Generally, it is generally assumed that the debt collector will provide merely proof of the existence or legitimacy of the debt. And the reason why it's not defined in practical reasons is that the validation or verification of the debt is probably going to be different amongst the various types of debt collection that may go on. A medical debt, validation of the debt may be the EOB or an itemized statement. For a credit card debt, it may be the itemized statement or the charges or may even the contract. For apartment leases, other types of debt that have a contract, it may actually be the contract itself. So the statute does not provide any restrictions as to what validation is. The standard is if you provide the consumer with some existence or authorization or acknowledgement that the debt is legitimate. We'll talk about the quality of the validation when we talk briefly about how that entails with the Fair Credit Reporting Act and the obligations of credit bureau reporting and the information that's provided. But generally, when someone asks for validation, it's the debt collector's obligation to cease communications until validation is provided to the consumer. So it does provide, once a consumer does provide a request for validation within that 30-day period of time, the debt collector must cease communications, cease all collection activity until validation is provided. If the validation is requested outside of the 30 days, there's no legal requirement that a debt collector provide that validation, but in practical speaking, and in industry standards, validation will be provided by the debt collector because it's part of collecting the bill. If a consumer receives proof that they went to the radiologist, did run up that charge card, did obtain that medical service at a particular time, more than likely they're going to be willing to pay that bill by being provided the proof of that existence of the debt. The next part also is required in writing. It's probably the least used of the information. But if a consumer requests information regarding the name and address of the original creditor, if it's different from what is being collected, that also can be in writing as well. You don't really see this unless there's really a debt buying opportunity in this. Sometimes a debt buyer will send out a collection letter saying that we are now have taken assignment of the bill from JCPenney's, Bank of America. But it's generally, in practice speaking, that debt collection letter will have the original creditor's name on there because the consumer may not recognize ABC debt buyer as owing the money to them. So the correspondence that a debt buyer may send out may say the original creditor is Bank of America, JCPenney's. But if a consumer writes in and says, I've never done business with ABC Collection Agency, who's the original creditor? If they do that in writing, the statute allows them to obtain the name and address of the original creditor so they know who the debt is owed by. The other types of disclosures that are required in FDCPA compliance is under Section 1692E11. In the first communication, it's required to provide what the industry calls the mini Miranda. And the mini Miranda under 1692E11 is a phrase that says, this is an attempt to collect a debt, and any information used will be used for that purpose. It's in the slide. Use this information verbatim. This is what's called the mini Miranda. It's usually put on the initial disclosure letter that goes out. You're more than welcome in your disclosures, subsequent disclosures, to use the mini Miranda. There's no harm, no foul to using the mini Miranda in subsequent communications. But at a minimum, 1692E11 requires you to use a phrase or the information that the communication is from a debt collector. The Fair Debt Collection Practices Act was amended recently to eliminate the requirement to use the mini Miranda in all communications. The trade-off was, well, you can use it in your initial disclosure, but any subsequent communication thereafter, you're at least supposed to notify the consumer that you're a debt collector. This not only applies to written communication, but it also applies to oral communications that are made between the debt collector and the consumer. So therefore, in the abundance of caution, the best practical point is to just say this communication is from a debt collector on any written communication thereafter.